a reasonable bond and also ask you to sign a photo order as well.
Okay, I'm gonna set bond on count one at $5,000, count two at $5,000, count three is no bond hold. I do find probable cause, and there will be no victim contact, direct or indirect, with the victim. You cannot go within 500 feet of the victim. No guns, ammunition, weapons of any kind. No calling, emailing, writing, texting. Don't visit or even drive by the victim. And if you need to get clothing from any property of the home, have someone else go for you. Thank you.
Thank you, Judge.
Okay, Jonathan Moreno Cerezo.
Judge, he is present at Maine. We're going to require a Spanish interpreter.
Okay, we're gonna put him aside and wait for the interpreter to get here.
Thank you. Toma asiento, por favor.
Kevin Timon Thomas.
He's in North Broward, Judge.
North Broward, Your Honor.
All right, and I do find probable cause. State, do you have any priors?
Your Honor, I'm showing he had in 2014 against a different alleged woman, different woman, convicted of aggravated assault and battery. He also violated probation in that case. Based on his prior domestic and the level of violence alleged in this case, state will be requesting a $3,500 bond and no victim contact.
Okay, Mr. Reed.
Your Honor, Mr. Thomas has been living in Florida for 3 years. He has family in Dade County that he hopes can assist him in bonding out. He's been living in the same residence for the last year. He believes he might be able to come up with a $1,000 bond unless pretrial release was willing to take him. So I'd ask the court for a $1,000 bond or pretrial release.
Your Honor, I've been with the victim for a whole year, and no
Okay.
incident has
Don't,
happened.
don't talk about the facts of the case, Kevin.
All right, I'm going to, based on representations by both sides, I will reduce the request to $1,000, but I'm going to put him on pretrial. No contact with the defendant, direct or indirect with the victim. You can't go within 500 feet of the victim. No guns, ammunition, weapons of any kind. No calling, emailing, writing, texting. Don't visit or even drive by the victim. If you need to get clothing or any property from the home, have someone else go for you. Good luck to you, sir. Okay, Alan Jerome
Still
Glassford.
got to talk pretrial.
Mr. Glasser, you're present, Judge, at Maine.
Okay, I do find probable cause. She charged with touch or strike battery, domestic violence. State any priors.
Yes, Your Honor. He has a battery in 2005. So just I think for the court's consideration, this could be treated when a filing decision is made as a felony battery with a prior. 2003 burglary of a conveyance and theft. He violated probation in that case. Was sentenced to 364 days in county jail. Your Honor, based on his criminal history, state would be and the allegations in this case, state would be requesting a $3,500 bond and no victim contact.
I would just add, Judge, that the victim refused to cooperate with the investigation.
Judge, and speaking Mr. Glasper, he's 33 years old. He's been residing in our community his whole entire life. He is employed. He works for a company called Vico Windows. He's a service technician. He's been steadily employed with the same company for over 11 years. He makes approximately $17 an hour. The alleged victim is his girlfriend. He will be living separate and apart from her. He has family members that live in our community. He's actually going to be staying with a family member who resides in Pompano Beach. Financially, he has no property. He is hoping that his family, his mother, will help post his bond. Judge, we'd be asking you to consider $2,000 on Mr. Glasper's behalf.
Okay, I'm going to, based on the ties to the community, I am going to set bond at $2,000, no contact, direct, and put him on pretrial. No contact, direct or indirect with the victim. You can't go within 500 feet of the victim. No guns, ammunitions, or weapons of any kind. No calling, emailing, writing, texting. Don't visit or even drive by the victim. If you need to get clothing or any property from the home, have someone else go for you.
Yes, Judge.
If you allow me to take your docket out of order, I got Judge Ehrlich is hailing me. I'm doing her courtroom 5 minutes
which
ago.
case do you want?
I got a couple on page 6. Donna McCarthy, she's a municipal ordinance case. George Odom
Just
saying.
let me go one at a time.
Sure, no problem.
And
Judge.
what's the name of the case?
Donna McCarthy, last name's McCarthy. She's on page 6 of your docket.
Okay. All right.
McCarthy is at North Broward, Your Honor.
Okay, she's charged with municipal ordinance and has
Come on,
a
Doc.
habeas of $250.
Yes, seeking appointment on to her case. And if the court is willing to get involved, we'd like to resolve today if possible. And seeking appointment actually on both of her cases. They're both MO violations.
Okay. How many days did she have in?
Yesterday and today.
And does she have any priors?
Your Honor, I would need her BCCN number. It's on the top of her booking sheet.
Okay, does she have anywhere to go?
Judge, to my limited knowledge, I'm not 100% certain, but if you allow me to inquire, I'm definitely
Are you serious?
Okay, Ms. McCarthy, please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Okay, do you
Yes.
have anywhere to go if you get out?
Yes.
Okay, you have a place to live?
I can go to my granddaughter.
Okay. I will appoint you to the case, and I will, please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay. Do you understand English?
Yes.
How far did you go in school?
7th grade.
Do you understand the charge? Do you
Not
understand?
really. Not really.
You were panhandling and you had a capias on another case?
Okay.
Do you
All right, sir.
understand now?
Yeah.
Do you wish to enter a
Yes.
plea? Do you wish to enter a plea of guilty or not
I
guilty?
wish I could just get this over with today.
Well, do you wish to enter a plea of guilty?
Yeah, I guess so.
Okay. I'll accept your plea and I'll sentence you to an adjudication court cost.
Thank you, Judge. And
Okay,
Judge,
could you tell me what does that mean, Your Honor?
That I just resolved the violation of the municipal ordinance.
Okay. And that means I don't have to pay no fines or nothing because I don't have money.
You're gonna have a year to pay. And if you
I
don't
don't have
pay,
any
you
money.
can go to request a civil lien. Okay?
But I don't have any money at all, for
Okay.
real. So what would be a year to pay? If there was a year?
I'll let you talk to your lawyer. I just resolved your case. That means you can get out of jail.
Okay, thank you.
And you could go see your grandkid.
Judge, I'll provide
Great
a second,
grandkid too.
Sell one. Go
provide
ahead
a
back.
second order because I only had 2 on me, so I'll bring back a second order for the 2173 case for the
Yes,
person.
and both of them will be resolved.
Thank you, Judge. Page 9 also have Tremel Kelly. Kelly's the last name on page 9 of the court's docket.
What's that? Public defender's right there. But he
Okay,
just picked
Jamil,
something that he wants.
she has 2 violations, yes.
Again, seeking appointment on
what?
her case.
Where is he?
Maine.
Okay.
Should be in Maine.
I do find probable cause for both.
Who is it that we're looking for, Judge?
Tremel
Male
Kelly.
Kelly.
Mr. Kelly? Jamel Kelly? What page is he on, Judge, so we can try to... Page 9. Kelly! Oh, he was all the way in back, Judge. He's approaching now.
No cars. A couple people. They call me, and we don't want a couple people.
Yeah, those
Get the details.
Okay. What would you like to do, counsel?
Judge, if Mr. Kelly is inclined to resolve, then we would ask the court to
Well, I
let him
think
go.
Okay, I didn't want to resolve this case based on the facts of the probable cause affidavit. And,
Yeah, let them.
I'm gonna set bond at $50 on count one and $100 on count two, based on the nature of the charge.
And we are appointed on.
I'll appoint you on both.
Thank you, Judge. Last, and I'll get out of your hair, page 10, at the main jail, Tony, what's the word? Ehrlich? ENRLICH, page 10.
Yes. Okay. He has, a number of capiases, one set for 500, one set for 250, one set for 100. He has a status on May 18, 2017 at 10 a.m. for one, and the other May 22nd, 10 a.m. Thank you. Have a great day.
You as well.
Do I need an order to? Okay, getting back to the regular docket, Robert Kalora.
How much you check is it?
He's here at Maine. Mr. Kalora, come on up, please.
Okay, he's been charged with a touch or strike battery, domestic violence. I find probable cause. State any priors.
Out of the state of New York, 1998, criminal possession, controlled substance in the second degree, and conspiracy. He was sentenced to state prison. Your Honor, state is going to be seeking a $3,500 bond based on his prior, the alleged violence in the case, and also noting that in this case, the victim was cooperative and provided a sworn statement, and that she does want to prosecute.
Okay, counsel?
Judge, in speaking to Mr. Kalora, he's been residing in South Florida now for about the past 5 years. He is 44 years old. He's currently employed. He works for Miami Phone Communications. He's been with that company for 2 months. He just started. He makes approximately $25 an hour. He has no money in the bank, no property. He will be living separate and apart from the alleged victim, who is his fiance. Judge, we'd be asking you to set a reasonable bond as to Mr. Kalora's behalf.
Okay, I will set a reasonable bond of $3,500 based on the allegations in the probable cause affidavit and his danger to the community. After finding probable cause, there will be no victim contact, direct or indirect. You can't go within 500 feet of the victim. No guns, ammunition, weapons of any kind, no calling, emailing, writing, texting, don't visit or even drive by the victim. Going to Rico Martin.
It's a meta reset, Judge.
Medical reset. Okay, Christopher Clody.
He's in North Broward.
That's North Broward, Your Honor. Come on, Mr. Claude.
Okay, Mr. Clody, you've been charged with domestic battery by strangulation, battery causing bodily harm, domestic violence, false imprisonment, and tampering in third-degree felony. Okay, state, does he have any priors?
Actually, Your Honor, if I may, he was arrested in January of 2017 for battery against the same alleged victim and hindering communication with law enforcement. And, Your Honor, some of the allegations are strikingly similar. If the court would like, I could provide the court with a copy of the probable cause affidavit in that matter. And obviously, I'd provide defense counsel also if you'd like to see it.
What's your recommended bond?
Your Honor, I can also advise the court that our office had contact with the alleged victim, and she is in fear for her life, terrified of Mr. Clody. He also, just to advise the court, I'm sorry, he was arrested in 2013 in Stewart for battery. That was dropped, and had a disorderly intoxication 2012. Your Honor, the state is going to be requesting a $25,000 bond on one, $5,000 bond on two, a $5,000 bond on three, and a $5,000 bond on four. No victim contact, and should he post his bond, state would be requesting that he be supervised by pretrial release services with a GPS monitor.
Okay, counsel?
Your Honor, the state's recommendation is tantamount to no bond at all from Mr. Clody. He would never be able to come up with the financial wherewithal to post that. He is a veteran of the Navy. He served our country from 1997 to 2001, received the General Honorable Discharge. He's been living here in South Florida since 2010. He has family in Naples. He's been living at the same residence for 2.5 years. He would not be going back to that residence. He has a place to stay where he would not have to have contact with the victim, and he would abide by all court instructions not to have contact with the victim. He believes that between friends and family, he can come up with approximately, if possible, $500. So I would ask the court to set a bond in the amount of $5,000 total.
And, Your Honor, what I want the court to be aware of, what I was referring to before, in the previous probable cause affidavit, there were allegations of a sexual nature in that case as well.
Okay, just not even looking at that, but hearing the priors and seeing the facts of this case, I find him to be in extreme danger to the community. I'm going to set bond at $25,000 on count 1. Count 2 will be $10,000. Count 3 will be $5,000. And count 4 will be $5,000. So that will be $35,000, $40,000, $45,000 total.
And, Your Honor, as far as the state's request for a GPS monitor?
There will be no victim contact, direct or indirect. You can't go within 500 feet of the victim. No guns, ammunitions, weapons of any kind, no calling, emailing, writing, texting. Don't visit or even drive by the victim. If you need to get any clothing from the property or home, have someone else go for you. As well, there will be pre-trial with a GPS ankle monitor.
Or level 2, he can work. He has to provide a schedule.
Level 1. Okay, Ronald McDonald.
Judge, Mr. McDonald's here present at Maine.
Okay. Sir, you've been charged with domestic battery by strangulation. State, does he have any priors?
Your Honor, I'm showing a battery from 1999 that was pled down from a felony. Based on the prior battery and the level of violence alleged in this case is strangulation, the state would be requesting a $7,500 bond and no victim contact.
Judge, in speaking with Mr. McDonald, he's been residing in South Florida for over 20 years. He's 45 years old. He is currently employed. He works for a company called Apex Marine. He's been working for them for about 6 months now. He's a travel lift operator, making approximately $23 an hour. Financially, he only has about $300 in the bank. The alleged victim is his wife. They do have 6 children that reside in the household. I know she's unemployed, so he's the sole financial provider of his family. Judge, he will be living separate and apart. He has members of his family that live in our community in Broward and Pompano. Judge, we'd be asking you to consider a $3,500 bond on Mr. McDonald's behalf. We'd also ask you to sign 2 other orders. One, a phone order allowing him access to his phone in order for him to get the contact numbers in order for him to try and contact his family and post his bond. That would be one order. As I mentioned before, they do have children in common. He was the one that actually drives the kids to and from school. He drives them to and from their activities. I'd be asking you to sign an order allowing for contact for purposes of arranging child visitation through a third party, so therefore he can still be involved in his children's lives.
Okay, and what was the request for?
$7,500, Your Honor, from the state.
And Judge, I don't have a probable cause argument really, but this probable cause affidavit is bereft of any details at all. It's the barest, scantest meeting of probable cause that could be possibly imagined. So we really don't know a lot of the details of what happened here, and I think that lack of knowledge should benefit Mr. McDonald.
Okay. That's a very good argument. I will set bond at $3,500. No victim contact, direct or indirect. You can't go within 500 feet of the victim. No guns, ammunitions, weapons of any kind. No calling, emailing, writing, texting. Don't visit or even drive by the victim. If you need to get clothing or any property from the home, have someone else go for you. There will also be phone access motion I'm going to grant, and I will allow contact with the children through third-party visitation.
Thank you very much,
Thank
Judge.
you.
Appreciate
Good luck,
that.
sir.
Thank you.
Patricia Legree.
Paul Ryan.
Judge, the Spanish interpreter is here.
And do we need her for Paul Ryan, for Patricia Legree?
No, Your Honor. One of the cases we have on recall, we did
Yeah.
have the Spanish interpreter.
Thank you. Okay, Ms. Legree, you have 5 capiases all set at $100 for case 17-001415 MO 40A. So your bond will be $100 on each, actually 1, 2, 3, 4, 5, on all 6 cases. Okay, you'll have a hearing shortly in that division. Good luck to you. Okay, let's go back to the case with the interpreter. Jonathan Moreno Chorizo.
He's here present at Main, Judge.
Okay, he's been charged with a touch or strike battery, domestic violence. I find probable cause.
Se le acusa de agresiones por violencia doméstica por medio de un toque o un golpe. Considero que hay causa probable. Could you repeat the last part of what you said?
I find probable cause.
Considero que existe causa probable.
State, do you have any priors?
¿Hay antecedentes?
No criminal history, Your Honor. State is requesting a $1,500 bond and no victim contact.
No hay antecedentes, su señoría. La fiscalía solicita una fianza de $1,500 y que se le prohíba tener contacto con la víctima.
Judge, in speaking, Mr. Moreno, as the state confirmed, this is his first arrest ever. He's been residing in South Florida for 3 years. He is 26 years old.
Señor juez, como dice la fiscalía, no tiene antecedentes. El señor Moreno ha vivido en el sur de Florida durante 6 años, tiene 26 años.
He's currently employed. He works for a company in Coral Springs called 4 Rentals, and he's a handyman, and he's been with them for about a year and a half, making about $500 per week.
Actualmente trabaja para una compañía que se llama 4 Rentals. Trabaja como misceláneo, como técnico de reparación para ellos. Ha trabajado para esa compañía durante año y medio aproximadamente y gana $500 por semana.
Judge, the alleged victim is his girlfriend. He does realize, I explained to him he'll have to live separate and apart from her. He'll be residing with his mother, who resides in Hollywood.
La supuesta víctima es su novia y yo le he explicado que ya no puede vivir con ella y él entiende y acepta eso. Estaría viviendo con su madre que vive en Hollywood.
Judge, considering this is a misdemeanor offense and it is his first, Mr. Moreno's first arrest ever, we'd respectfully be requesting a $1,000 bond.
Considerando el hecho de que esta es una contravención y es la primera infracción del señor Moreno, solicitaríamos respetuosamente una fianza de $1,000.
Okay, I will set bond based on his priors, lack of priors, and the nature of the charge after seeing probable cause. I will set bond at $1,000. No victim contact, direct or indirect, with the victim.
Bien,
You can't go within 500 feet of the victim. Do I need to slow down, sir?
Yeah, I'll interpret what you just. Con base en lo que he dicho y también mi lectura de la declaración jurada sobre causa probable y tomando en cuenta
No
lo
guns.
que acaba de decirse es voy a fijar una fianza de $1,000 y se le prohíbe tener contacto con la víctima, no se puede acercar a ella a una distancia mayor a 500 o menor a 500 pies.
No guns, ammunitions, or weapons of any kind.
Se le prohíbe tener armas de fuego, ningún arma de ningún tipo, ninguna munición de ningún tipo.
No calling, emailing, writing, texting.
Tampoco comunicarse por vía telefónica, ni por correo electrónico, ni mediante mensajes de texto, ni por escrito.
Don't visit or even drive by the victim.
No visite ni tampoco tan siquiera conduzca en un área cercana a donde la víctima esté.
If you need to get clothing or any property from the home,
Si necesita retirar alguna ropa o cualquier propiedad personal suya de la casa,
have someone else go for you.
entonces pídale a alguna otra persona que le haga el favor de ir a hacerlo por usted.
Okay, good luck.
Bien, buena suerte.
Thank you.
Thank you. Okay, Mercedes Martinez.
Judge, do you want me to announce anybody else who requires a Spanish interpreter at this time?
Well, he's here, so we can get started.
Okay. ¿Español? ¿Alguien habla español solamente? There is one person, Judge.
Okay.
Ven. ¿Qué es su nombre?
Bernardo.
¿Qué?
Bernardo Mercader.
Bernardo Mercader? Michaela. What? Bernardo Mercader. Let me try and find him, Judge. Bernardo Mercader.
Page 12, I think, Hector.
Found him. Thank you.
How do you spell the last name?
Mercader, Mercader. It's like in the middle of the docket. Demetrius?
I found him. Okay. Sir, you were charged with a DUI.
Bien, a usted, señor, se le acusa de conducir bajo los efectos del alcohol o drogas.
I find probable cause.
Considero que existe causa probable.
State, do you have any priors?
¿Hay antecedentes? Se le pregunta a la fiscalía.
Your Honor, he's not on my list. Does pretrial have a criminal history?
Señoría, no está en mi lista. No sé si el Departamento de Investigación Preliminar.
DUI.
Un cargo de conducir bajo la influencia en el 2004.
1997 aggravated assault with a weapon.
Lesiones o agresión agravada con arma en 1997.
1987 disorderly conduct.
Conducta desordenada en 1987.
And 1987 burglary and possession of burglary tools.
Y hurto y posesión de herramientas para hurto en 1987.
Counsel?
Judge, he's been residing in South Florida for 36 years. He's 55 years old. He's currently employed. He works for a paving company. He's been working with that company for 22 years, making about $12 an hour.
Su señoría, el señor ha vivido en el sur de Florida durante 36 años, tiene 55 años de edad, ha vivido, ha trabajado para una compañía de asfaltado durante 22 años, ganando aproximadamente $12 por hora.
He lives in Fort Lauderdale. He lives in a trailer. His monthly rent is about $675. Judge, financially, he has limited resources. We'd be asking you to consider a $2,500 bond on Mr. Mercader's behalf.
Su señoría vive en Fort Lauderdale, en una casa rodante donde paga aproximadamente $675 mensuales de alquiler. Tiene recursos económicos limitados. Solicitaríamos respetuosamente que se le fije una fianza de $2,500.
And Your Honor, based on his, based on his prior and the breath results in this case, 291 and a 295, state's going to be requesting a $5,000 bond and an additional condition of no alcohol or intoxicants.
Su señoría, dado los resultados de la alcoholemia en este caso, que dieron 291 y 295, solicitaríamos que se imponga una fianza de $5,000 en este caso y que también como requisito adicional se le imponga el deber de no consumir alcohol ni sustancias intoxicantes.
Okay, based on his priors, I consider him to be a danger to the community, but I also consider him to have ties to the community. Based on the nature of the charges, I'll set the bond at $3,500.
Bien, con base en sus antecedentes, considero que constituye un peligro para la comunidad. Sin embargo, también dada la información presentada, es obvio que tiene lazos con la comunidad también, por lo cual voy a fijar la fianza en el monto de $3,500.
Thank you.
There's one last person, gentlemen, that's going to require Spanish interpreter. His name is Manuel Gregorio Hernandez. Miguel Gregorio. He is on page 15 of the docket.
We would waive formal reading of the nature of the charges, Your Honor.
Su señoría, nosotros en este caso renunciaríamos a que se lea formalmente el pliego de cargos.
Okay. State, what's the priors?
¿Cuáles son los antecedentes, Fiscalía?
Your Honor, he has no criminal history.
Su señoría no tiene antecedentes penales.
That being said, these allegations, Your Honor, actually would support a punishable by life offense because of the nature of the relationship between
¿A what offense?
the nature punishable by life
Okay.
offense.
Sin embargo, su señoría, dada la naturaleza de estas acusaciones, estos cargos potencialmente son penables hasta con cadena perpetua.
Based on the nature of the relationship between Mr. Gregorio Hernandez and the alleged victim.
Dada también la naturaleza de la relación entre el señor Hernández y la supuesta víctima.
Additionally, just noting, according to the booking sheet, he was born in Guatemala.
Y según la hoja de fichaje, nació en Guatemala.
With 7 months of residence at the listed address.
Ha vivido durante 7 meses en el domicilio que figura en la lista de cargos.
I have concerns about his ties to the community.
Tengo preocupaciones con respecto a la fortaleza de sus lazos con la comunidad.
Your Honor, the state would be seeking $150,000.
La fiscalía solicitaría una fianza de $150,000.
Should he post his bond pre-trial release with the GPS level 1?
Y si lograra pagar su fianza, entonces solicitaríamos que se le imponga el régimen previo a juicio con GPS, un monitor de GPS nivel 1.
And no victim contact.
Y que se le prohíba tener contacto con la víctima.
Judge, in speaking, Mr. Gregorio, that is true. He's been residing in South Florida now for about 7 months.
Su señoría, sí es cierto que el señor Gregorio ha vivido acá en el sur de Florida durante 7 meses.
He's currently employed. He's a day laborer. So whenever he gets work, he gets paid approximately $100 a day.
Actualmente tiene empleo, es jornalero. Y cuando se le pagan aproximadamente $100 por día.
Financially, he has no money in the bank, no property. However, he does live in Pompano. He currently is renting a room. The monthly rent is approximately $600 a month.
Económicamente carece de recursos y no tiene tampoco dinero en el banco. Sin embargo, sí está viviendo en Pómpano, está alquilando una habitación por el monto aproximado de $600 por mes.
Judge, we'd be requesting you to consider setting a $10,000 bond. The $150,000 bond, which the state is requesting for this individual, would be tantamount to no bond. So therefore, we'd be asking $10,000 and ask you to sign an order allowing him access to his phone.
Su señoría, solicitaríamos respetuosamente que se ponga una fianza de $10,000 en este caso. El monto de $150,000 que está solicitando la fiscalía para efectos prácticos es igual que negarle completamente la fianza. Solicitaríamos eso y también que se firme una orden judicial permitiéndole acceso a su teléfono.
Okay, counsel, Mr. Gregorio Hernandez.
Señor Gregorio Hernández.
Your attorney has waived the formal reading of the charge.
Su abogado ha renunciado a la lectura formal de los cargos en su caso.
I've reviewed the probable cause affidavit in your file.
He analizado, he leído la declaración jurada sobre causa probable que consta en su expediente.
and I find probable cause.
y considero que existe causa probable.
I further find the proof of guilt to be evident or the presumption great.
Considero también que la prueba de la culpabilidad es evidente o que la presunción de la misma es grande.
Therefore, you're to be held without bond until further order of the court.
Por lo tanto, usted se mantendrá bajo custodia sin ninguna fianza hasta que una corte disponga lo contrario.
The order is without prejudice
Lo anterior es sin prejuicio
for the defendant to file a motion to set bond with the assigned division judge.
De que el acusado presente un recurso para que se fije una fianza ante el juez de la división que se le asigne.
And request the hearing under State v. Arthur.
Y que también podría solicitar una audiencia bajo la ley o, según el caso, del estado de Florida versus Arthur.
And, Your Honor, just for record purposes, I assume Your Honor is making a finding that these alleged acts were committed by someone with custodial authority.
Su señoría, simplemente para que conste en acta, la fiscalía le pregunta al juez si está hallando que estos actos fueron cometidos por una persona que tenía autoridad custodial o patria potestad.
Which would make it a punishable by life offense.
Lo cual sería equivalente a una pena penable, valga la redundancia, con cadena perpetua como máximo.
The defense would strongly object to the court holding Mr. Gregorio Hernandez without bond at this time, Judge. This case is not even listed on the docket as a first-degree felony punishable by life.
La defensa objeta vigorosamente a la imposición de custodia sin fianza. Este caso ni siquiera ni siquiera se ha ventilado todavía.
Mr. Gregorio Hernandez has not been charged with an act in familial custody.
El señor Gregorio Hernández no ha sido acusado de un acto que se haya cometido bajo una situación de custodia familiar.
He is presumed to be innocent.
Y se le presume ser inocente hasta que se demuestre lo contrario.
If the state wants to amend the charge or come back with some type of perfection to the probable cause affidavit, that's something that they can request.
Si la fiscalía desea modificar los cargos o perfeccionar el cargo para mejorar la declaración jurada sobre causa probable, eso es algo que ellos pueden solicitar.
But the manner in which this case is presented to the court this morning, it is not a first-degree felony punishable by life.
Sin embargo, tal y como se le ha presentado a la corte en este momento, no es un delito mayor penable con hasta cadena perpetua.
And we would ask the court to set bond for Mr. Gregorio Hernandez.
Y solicitaríamos que la corte imponga una fianza para el señor Gregorio Hernández.
Okay, then to avoid any problem, based on the charge that has been filed in this court, at this point in time, is there an indication from the state that the charge is going to be changed?
Bien, para evitar cualquier problema con base en el cargo, de la forma que se ha presentado, en este momento le pregunto a la fiscalía si hay alguna indicación de que se vaya a modificar el cargo.
Well, Your Honor, first I would say I think...
Yes or no?
Solo sí o no.
Your Honor, I don't know. I can't possibly tell you what a case filer is going to file at this point in
And
time.
at this point, I'll set bond at the $150,000.
Bien, entonces en este momento se le impone una fianza de $150,000.
Then, Your Honor, the state would request 24 hours then to come back possibly with an amended probable cause affidavit.
Señoría, en ese caso la
At
fiscalía
this point, I'll do the
solicitaría
$150,000 bond.
un plazo de 24
If you want to
horas
amend something, you're entitled to do that.
para modificar el cargo. Si la fiscalía desea modificar algo, puede hacerlo.
And the state also made a GPS monitor request, Your Honor.
I will grant that as well.
La fiscalía también solicitaría que, de ser puesto en libertad, se le imponga el requisito de portar un monitor GPS. Y se le concede esa solicitud.
Okay.
Thank you, Judge.
Thanks, Mercedes Martinez.
Gracias. Is that all for the Spanish?
I think level one. Ms. Martinez, you were charged with touch or strike battery, domestic violence. State, does she have any priors?
She has 2 prior thefts, Your Honor. State would be requesting a $1,500 bond and no victim contact.
Judge, respectfully and speaking, Ms. Martinez, she's been residing in our community for her whole life. She is 28 years old. She was previously working at Publix. She was a cake decorator. She was working for them for 2 years, making about $10 an hour. Unfortunately, due to unforeseen circumstances, Judge, she had to take a medical leave. She was taking care of her premature child, who is currently at 5 months old. Judge, she also has 3 other children, ages 7, 3, and 2. Financially, she is a single mother. She has no money, no financial resource, no money in the bank. She owns no property. She is a registered voter here in Broward County. Considering her ties to the community, Judge, her lack of any sort of financial resources, being a single mother, being on medical leave, we'd be respectfully requesting for you to consider an ROR on Ms. Martinez's behalf.
And you said she had no priors?
A couple prior thefts.
Misdemeanors.
Okay.
I don't know what they were. Felonies, what is it? Grand theft.
I will do an ROR, but there will be no victim contact, direct or indirect. With the victim, you can't go within 500 feet of the victim. No guns, ammunition, weapons of any kind. No calling, emailing, writing, texting. Don't visit or even drive by the victim. If you need to get clothing or any property from the home, have someone else go for you. That would be it.
Thank you, Judge.
Thank you. Lottie Broderick Gibbs.
She's in North Broward.
North
Judge.
Broward, Your Honor.
Okay. You've been charged with a touch or strike battery and a violation of your injunction within 500 feet. State.
Does pretrial have any criminal history? Your Honor, state would be seeking a $1,000 bond on 1 and a $1,000 bond on 2, no victim contact.
Your Honor, Miss Braddock Gibbs has been living in Florida all of her life. She has a minimal criminal history. She has 2 daughters who live here, ages 25 and 27. She does not work because she is currently disabled. She has provided me with the number of her mother, who she believes could help bond her out, as well as a friend of hers. She's been living in the same residence for 1 year. She has a separate residence to stay so that she would not have to have contact with her sister. And it seems, is it her sister, her boyfriend, I'm sorry. And there seems to be some indication, at least here, that this was kind of a mutual combat situation. But in light of her lack of a criminal history, I'd ask the court to consider releasing her on her own recognizance.
Okay, I will do an ROR. I'll do no victim contact, direct or indirect. You can't go within 500 feet of the victim. No guns, ammunition, weapons of any kind. No calling, emailing, writing, texting. Don't visit or even drive by the victim. Okay. Cynthia Bowen.
Well, what happened?
She's in
I don't know. I
Broward.
wasn't. Come on.
What happened?
North Broward.
Good morning.
Whatever the man said to you.
Okay, there's been a touch and strike battery. State, any priors?
Yes, Judge.
You guys gotta listen for yourself when you're in there.
Grand theft 2016 VOP. Battery on a law enforcement officer 2013 VOP. Solicitation to deliver cocaine 2012 with the VOP. 2012 possession of cocaine. Prostitution 09. She's got theft 07, battery on a law enforcement officer 07, battery 07, battery 05, possession of cocaine 01, resisting without violence 99, felony credit card fraud, grand theft, forgery 98 with the VOP, possession of cocaine 96.
Anything to say, Mr.
Yes, Your Honor. Miss Bowen has been living here in South Florida all of her life. Her grandmother is a paralegal, and she's hoping her grandmother can maybe assist in bonding her out, if bond is reasonable enough. Unfortunately for Miss Bowen, she doesn't have a place to go right now. She would, if bonded out or released by the court, go to the Salvation Army on Broward Boulevard, where she has gone before. She's familiar with that location, and that is where she would be residing while waiting for this case to resolve itself.
I'll set bond at $1,000, no contact, direct or indirect, with the victim. You can't go within 500 feet of the victim. No guns, ammunition, weapons of any kind. No calling, emailing, writing, texting. Don't visit or even drive by the victim. Okay, thank you very much. Heather Hasley.
North Broward again, Your Honor.
I find probable cause. State any priors.
I'm not showing anything, Judge.
Miss, you've been charged with possession of cocaine, possession of cannabis, and drug paraphernalia. Counsel?
Your Honor, Ms. Hasley has been living here for some time. She's been staying in the same place for the last 6 months. She's been working as a waitress for the last 2 years. The amount of cocaine in this case is, I believe, residue in a pipe. I would be asking the court to consider, in light of the fact that she has no prior criminal history, I would ask the court to consider either pretrial release or an ROR in her case. I don't think she really has any money to bond out on her own.
Okay. I'll reduce bond to $500 on count 1. Count 2 will be an ROR. Count 3 will be an ROR.
So,
Thank you. Your bond will be $500. Shannon Woodworth.
North Broward again, Your Honor.
Okay. The charge is
morning.
possession of cocaine. Good morning. I find probable cause. State.
Yes, Judge. Her priors include
List is going in order.
possession of marijuana, 05, battery, 01.
Is that it?
Yes.
Your Honor, Ms. Woodworth has been living here in Florida for all of her life. She has friends and family here. She's had the same job bartending for the last 2 years. She has been to college at Nova Southeastern University. She is studying to be a dentist. In light of her lack of prior record, I would ask the court to consider releasing her on her own recognizance.
Okay. I'm going to reduce the bond to $500 and find probable cause. Thank you and good luck.
thank you.
Rochelle Sutton.
Paul Ryan, Your Honor.
You've been charged with grand theft. State.
She has just traffic priors.
Okay. Counsel.
Judge, Ms. Sutton has been living in Florida all of her life. She has no prior criminal history. She's been working for the same occupation for the last 3 years at Walmart. She stays with her daughter, who is, did you say 2 months old? How old is your daughter, Rochelle?
2 years old.
3 years old. And she's been living in the same location for the last 2 years. She believes her father will be able to bond her out, but in light of her prior record, Judge, I'd ask the court to either consider reducing her bond or releasing her on her own recognizance.
In light of the facts, I'll reduce the bond to $500. Okay. Good luck to you.
$50.
All right.
Thank you.
Christina Clark.
That's North Broward, Your Honor.
Okay, she's been charged with a false ID given to law enforcement, possession of controlled substance without a prescription, and she has a KPS on case 16-01409-6CF10A, where there's a no bond hold. State, what's the priors?
Well,
I do find probable cause.
one moment, Judge.
Judge, this is, oh, I'm sorry.
You can go.
Okay. This is kind of a tough one, Judge. Ms. Clark indicated to me that her grandfather passed away yesterday. Now, I know that there's nothing the court can do on the outstanding capias on the 1601 case, but I'd ask you to consider releasing her on her own recognizance on count 2, and I'll try and get her on a docket as fast as I can so she can get to the funeral if the court would be inclined to do that.
Well, Your Honor, well, first off, she has possession of cocaine 2012, prostitution 2011, possession of cocaine with intent to sell or distribute, possession of marijuana with intent to sell or distribute, possession of alprazolam 06 with the violation of probation, possession of marijuana 06, resisting without violence 03. If she's going to have to see her judge on her VOP anyways, Your Honor, I see no reason to ROR her on on count 2, Your Honor. She has a criminal history. She's violated probation in the past. Her judge, if her judge decides to release her on the VOP, then certainly her judge can ROR her on count 2 as well.
Is this a VOP or a capias?
Or on the capias. What I'm saying, if the judge reinstates her bond on the capias or RORs her on that, then the judge can ROR on count 2.
I agree. And what about count 1? That was a no charge?
I'll leave that to the court, whatever you want. I'm not asking for a bond on it.
Okay, I'm gonna ROR on count 1. Count 2 would be $1,000, and count 3 is the no bond capias. And that could be taken care of in the court.
Judge Gollop.
Yes.
I have one more female at North Broward. She's on the last page. Roni Lisa. Can we have her seen? You're done. You got $1,000 bond.
Just do me a favor.
And then you got to go see your division judge.
Judge and one to the PD over there. It's the perfection, Your Honor. I'm providing the court with the supplement right now.
Okay.
Just to advise the court before you read the perfection, the issue that Judge Levy-Cohen had was the original PC didn't really specify what the basis for the original trespass was for. Was it for Judge Lerner's courtroom? Was it for the courthouse? In the second paragraph of the supplement, the Deputy Lettieri provides some details as to the basis for the original trespass for Ms. Roney.
Going off the docket, guys. Going off the docket. I do this every day, man. I'm a
Lawyer psychologist.
I will not let it
Okay.
Executive order.
Ms. Roney, you were charged with
Yes.
trespass. Okay, does she have priors?
Yes, Your Honor. One moment.
And counsel, did you have?
At least in 48 hours.
I don't know if the court's inclined to try and resolve it today.
No.
I didn't think so. No, Judge, I don't have anything else to add.
And State, were you requesting anything more than $100 bond?
No.
I'm gonna set bond at $100. And
On who, me?
And I do find probable cause as perfected.
On who?
On you. You got $100 bond.
I don't have $100, Your Honor.
Okay, thank you very much.
That's it.
We'll go to
Judge's
Michael
Kidnapping
Bryant.
charge.
Michael Bryant. Okay, sir, you are charged with possession of cannabis and loitering or prowling. State, do you have any priors?
One moment, Your Honor. I'm showing his priors include he pled out a loitering and prowling in March of this year, theft last year, 2 counts of resisting without violence last year, possession of a felony controlled substance 2015, possession of heroin, resisting with violence, and attempting to deprive an officer of a weapon or communications device 2015. End of record.
Judge, the one thing the defense will be asking is when he was arrested, he had $100 in his property. I know as soon as you get arrested, I believe they take $23 from your property for the clothes rental. So what I would be asking you to do is considering lowering the bond from $100 to $50 so he can self-bond.
Okay, the bond on possession is $100. I find probable cause on the possession of cannabis and the possession and the loitering and prowling. I'll set bond at $100 as well. Thank you. Okay, Elvis Ramsey.
Mr. Ramsey is here present, Judge. Mr. Ramsey, come on up, please.
State, does he have any priors?
Your Honor, he's on my list. Like, he's not on my list. I can tell you he has no Broward history.
Okay. He's charged with a DUI, and I will find probable cause. Counsel, did you have anything to add?
Judge, the only thing we'd be requesting is a phone order.
Okay, I'll grant that, and since the standard bond's $500, that's what I'll say.
Thank you, Judge.
Okay, Kevin
Van
Van
Dunk.
Dunk.
North Broward, Your Honor.
Van Dunk. Oh, North Broward.
Yes.
Okay, I thought we were done with North Broward.
No, I just finished up my females.
Okay, no problem. Okay, Mr. Van Dunk, you have a capias. It's set for $100, and I find probable cause, and your bond will be $100. Good luck to you.
Oh, okay. Thank
Timothy Hines.
Mr. Hines, come on up,
He's
please.
charged with a touch or strike battery. State?
Mr. Hines does have criminal history. Actually, Judge, I'm sorry. I see a 2001, Your Honor, sexual battery. He violated probation. He was sentenced to 15 years in state prison.
Okay, counsel?
Judge, he does have family that live in our community. He's going to be calling his mother. We'd be asking you just to keep the standard bond in place.
Your Honor, state would be seeking a bond increase based on his prior and potential consequences he faces, because it would appear I would imagine he's registered, Your Honor, also.
Okay, I'm going to set bond at $1,000 after finding probable cause.
Thank you, Judge.
And I apologize, Your Honor, ordered no victim contact?
No victim contact, direct or indirect.
Mr. Hines,
You can't
hold
go.
on. The judge hasn't finished.
Yes,
Please
sir.
listen.
There's no victim contact. No direct or indirect contact with the victim. You can't go within 500 feet of the victim. No guns, ammunition, weapons of any kind. No calling, emailing, writing, texting. Don't visit or even drive by the victim. Good luck.
Thank you, Judge.
Wayne Reeses.
Mr. Reese is here present, Maine. Mr. Reese, Judge is respectfully requesting your honor to see if the court would offer a time served he wishes to resolve his case today.
Okay, that's nice, but he has a capias. He didn't show up. His bond is going to be set for $500, and his case will be set in the division, which he is. Thank you. Hebby Richard.
Mr. Richard, come on up. We can ask. Judge, Mr. Richard is here present respectfully. He'd be asking the court if your honor would consider resolving his case today for time served. Or in the alternative, withhold and take judicial notice of time served, Judge.
No, he has a capias set at $250. He can set his case in front of the division judge. I find probable cause. Thank you. Okay, case Michael Lynn Pittman.
Mr. Pittman is here present, Judge at Maine. He's also respectfully asking your honor if you would consider resolving today the case for withhold, take judicial notice of time served.
Okay, you have a trespass, sir. I find probable cause. State, do you have a recommendation to resolve the matter?
Your Honor, if I could have one moment, I'm just checking criminal history. Showing out of the state of Tennessee, disorderly conduct in 2015, bail jumping 2013, public intoxication 2012, domestic assault 2012, disorderly conduct 9, assault 2009, public drunkenness, vandalism 2008. State's offer would be adjudication 3 days.
Okay, if he'd like to resolve it based on his priors, I'll resolve the matter, adjudication, court costs 5 days, credit for time served. Would he like to resolve it, or would he like to have a $25 bond?
The judge is offering 5 days. It's up to you. If you presume that if you want to fight it, you can fight it, or bond out for $25.
I can hear you, counsel.
Oh, sorry. Let the judge know you want to accept his offer.
I'll accept your offer, Judge.
Okay, please raise your right hand. You swear to tell the truth, the whole truth, and nothing but the truth.
Yes, I do.
Okay, you can put your hand down. Do you understand English?
Yes, I do.
How far did you go in school?
12th grade.
Do you understand the
12.
charge?
Yes, sir.
Do you wish to enter a plea of no contest?
Sir.
I have, do you understand if you're not a citizen of the United States, regardless whether you're here legally or not, this plea will subject you to deportation? Do you understand?
Yes, sir.
Okay, I find you made a knowing, intelligent, and voluntary waiver of your rights, and I will accept your plea and sentence you to an adjudication, court cost 5 days, credit for time served. Okay, good luck to you, sir.
Sir.
Edward Clay.
Clay, let's go, Clay.
5 days.
Okay, he's been charged, or he's in on a capias, which he has a $500 bond on. I'm just gonna leave it at $500.
Yes, Judge.
Thank you. Travio Pierre Louis Robert.
He's here present, Judge?
Charged with driving with your license suspended and a capias on 17017-217 TC40A. I find probable cause. I'll set bond at, well, the bond on the capias is $250. The driving with the license suspended, I'd keep it the $100.
Thank you, Judge.
Thank you. Benjamin Holcomb.
Mr. Holcomb, come on up, please.
It's a touch or strike battery. State, and I find probable cause. State, do you have any priors?
Yes, Judge. Out of the state of Georgia, 2015 theft, 2014 theft. Looks like there's a violation of probation. End of record, Judge.
Okay, state, defense counsel.
Judge, we just ask you to keep the standard bond in place.
Okay, based on the nature and his priors, I'm gonna double it to $2,000.
And state would request no victim contact, Judge.
There will be no victim contact, direct or indirect. Don't go within 500 feet of the victim. No guns, ammunitions, or weapons of any kind. No calling, emailing, writing, texting. Don't visit or even drive by the victim. If you need to get clothing or any property from the home, have someone else go for you. Thank you.
Judge, we'd be asking you if you would sign a phone order allowing access to his phone so he can contact someone on him out. Thank you.
Granted. John Edward Newsom.
He's approaching, Judge. She's all the way in the back.
Judge, Mr. Newsom's here. Judge, he's respectfully asking you to consider resolving his case today. As you notice, his case is from 2008. Therefore, Mr. Newsom is requesting that.
State, do you have an offer or an objection? I don't like resolving the capias cases, however, it is from 08.
Yeah, he would just, I would just need him to be advised. Well, he's got 4 prior, so this would be the first within a 5-year period. State's offer would just be adjudication time served.
Would you like to resolve that?
Yes, I would.
Please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
You could put your hand down. Do you understand English?
Yes, I do.
How far did you go in school?
Completed high school,
Do you
fourth grade.
understand the charge?
Yes, I do, sir.
Do you wish to enter a plea of no contest?
Yes, I do.
Do you have any questions for your attorney?
No, I don't.
Do you understand the minimum and maximum penalties?
No, that wasn't explained. I'm sorry.
Excuse me. Sorry?
Minimum and maximum.
Oh. I didn't hear what was going on. I apologize.
I asked him if he understood the minimum and maximum penalties. I believe the minimum penalty is a withhold court cost. I'm going to sentence you to an adjudication court cost. The maximum penalty is 60 days in jail and a $500 fine.
Do you understand what the judge
Do you
said?
understand that?
Yes, I understand.
Okay. Has anyone threatened you, coerced you, or promised you anything to get you to make that plea?
No, sir.
And are you under the influence of drugs, alcohol, any other substance, or do you suffer from any mental illness?
No, sir.
And do you understand that the plea could serve as a basis for your license being suspended, revoked, or you being declared a habitual traffic offender?
Yes, sir.
And do you understand if you're not a citizen of the United States, regardless whether you're here legally or not, this plea will subject you to deportation?
Yes, sir.
I find you made a knowing, intelligent, and voluntary waiver of your rights. I accept your plea, and I'll sentence you to an adjudication court cost. Okay? Thank you.
Thank you, sir.
Matthew St. Pierre.
Mr. St. Pierre is approaching, Judge. He declined the services of public defender.
Okay, sir, you've been charged with grand theft, traffic and counterfeit credit cards, illegal use of a credit card, and you have a warrant on a violation of pretrial with a no bond hold on case 17-005056CF10A. State, do you have any priors?
One moment, Your Honor. It looks like there was a battery that was dropped in 2015. Based on the no bond hold on 4, I was just going to be asking that the convenience bonds on 1 through 3 be kept in place.
Okay. I'm just going to do the standard bond based on the charges and the prior. Count 1 will be $1,000. Count 2 will be $5,000. Count 3 will be $1,000, and the pretrial felony warrant is a no bond hold. I do find probable cause. Good luck, sir.
Hey, do you, for the no bond, do you think I could get a bond for my ankle monitor, because I did not, everything that they told me to do with my ankle monitor I was compliant with.
Okay,
it's just that
sir, before you put anything that you might regret on the record, you can set a hearing date right away with the judge that you're going to have your case in front of, and you can make your arguments in front of him or her, and they will be able to change the conditions. And the sooner you file the motion, the sooner you'll be heard.
I don't want to. It's not that I don't want to do another hearing. It's just that I'm stuck in here and I can't. I never got a court date for my.
Well, you might want to entertain the services of the public defender, who could file a motion on your behalf right away. Okay. Have a seat and talk to him, and good luck to you. Thank you.
Okay.
Adrian Daniel Bueso. Bueso. Okay.
Mr. Bueso, it's your present, Judge?
Yes. He's charged with carrying electric weapon or device, possession of cannabis, drug paraphernalia, possession, and he has a probation violation of case 16-000-607 CF10A with a no bond hold. It's a violation of probation, May 17, 2017 at 9 a.m. State?
Yes, Judge.
Any recommendation on the other three charges?
You know, with the VOP, Your Honor, I was just going to ask that the bonds be left where they are. He'll see his felony judge. That's certainly the more important issue.
Okay, count one, I'll do a $100 bond. Count two and three, I'll do an ROR. Count four is a no bond hold. Okay, Desmond
Thank
J.
you.
Arlene.
North Broward, Your Honor, North Broward.
Okay, sir, you've been charged with a petty theft and a possession of cannabis. State, do you have any priors?
Yes, Judge.
I do find probable cause.
And trespass 2015, trespass 2015. Got improper exhibition of a weapon 2014, theft 2014, delivery of cocaine 2012, delivery of a counterfeit controlled substance 2010, unlawful use of false name ID 09, contributing to the delinquency of a minor 09, tampering with evidence 07, possession of cocaine 05, theft 06, resisting without violence 05.
Did you request an increase in the standard?
No, I was just going to ask for the convenience bond.
Counsel?
Judge, I believe he has a friend of his who's be able to bond him out. I don't know how much money they have, though, and I know he's got a bit of a history, but the allegation here is that he stole a can of beer. I'd ask the court to consider reducing his bond.
Any objection?
No, Your Honor.
Okay, I'll reduce the bond to $100. Count two will be $100.
Thank you, Judge.
Okay? Aladdin Ruiz.
Mr. Ruiz is here present, Judge of Maine.
Okay, Mr. Ruiz was charged with possession of cocaine and possession of cannabis. State, any recommendation
One moment, Your Honor.
or priors?
Prior arrests, it looks like they were dropped. I'll leave in the court's discretion.
Standard bonds $1,000. Counsel, do you have any requests?
Judge, Mr. Ruiz is requesting if you would consider lowering his bond from $1,000 to $500. He works as a floor technician installing carpets. He's a single father of 2 children. He lives in Fort Lauderdale. He lives at his brother's house. He advised me his financial resources are very limited, and that's why we'd be requesting you to consider reducing it from $1,000 to $500. He's also currently going to school. He's trying to get on the right track to get a career so he can have provide a better future for his children, Judge.
Okay, I find probable cause. I'll set bond on count one at $500. ROR count two.
Thank you, Judge.
Jeff Blacher.
Mr. Blacher, come on up, please.
Okay, you are charged with driving with your license suspended and improper backing. He has a probation violation on 1609956 CF 10A and 17401 CF 10A. Both of those have a no bond hold. They're set June 5th, 2017 at 8:45. Any objection to the standard bond on the others?
No.
Nothing.
I'll set $750 on count one, count two, all ROR. Count 3 and 4 are no bond holds. And I find probable cause. Tedrick Lewis.
Mr. Lewis?
Okay, he's charged with resisting an officer, carrying a concealed firearm, possession with intent to sell, possession of cocaine. He has a capias on felony 162547 CF 108. He has a capias on 162647 CF 108. He has a capias on 171560 MM 108 and a capias on 160061 TC 30A. The capiases, 2 of them are no bonds and 2 of them are 1,000 each. There's to be set in the division. State, do you have any recommendation other than standard bond, and does he have priors?
On Tedrick Lewis, I was just going to be asking for the convenience bonds, Judge.
Judge, the only request as far as the defense is if you would sign a photo order allowing his photograph. Mr. Lewis's injuries, considering he has a no bond hold.
Okay, I will do that. I'll set bond at $100 on count one. Count two will be $1,000. Count three will be $1,000. Count four will be $1,000. Count five is a no bond hold. Count six is a no bond hold. Count seven is $1,000. Count eight is $1,000.
Thank you, Judge.
Thank you. Anthony Chamera.
Mr. Chamera, come on up, please. Anthony. Anthony Edward Chamera. Oh, he might be in the restroom, Judge. They're going to find him right now.
We'll call him when he comes.
Judge Gottlieb, you skipped Mr. Jerry Edwards on page 16.
I'll come to him.
You were supposed to.
I'll come to him in a second.
Okay.
Mr. Chamera?
Mr. Chamera, they're still,
Okay.
I believe,
Then
going to
I'll
get him
come
from the
back to
restroom.
him in a minute, and we'll go back to Jerry Edwards.
Come on, Mr. Edwards. Come on, Mr. Edwards. Stand on the X there for me.
Okay, Mr. Edwards, you were charged with grand theft. You have a capias of $1,000 on that count. State, did you have any recommendation?
Your Honor, I'm fine with the bond being kept at
Okay.
1,000.
Mr. Reedy?
Judge, Mr. Edwards has been staying here in the same location in the Fort Lauderdale area for the last 45 years. He has family here, including his mother and his brother. He's not sure how much bond they are going to be able to come up with. He gets a disability check, but he will not get his disability check until the 1st of the month, which is 2 weeks away. He also just recently underwent a medical procedure that is causing him a great deal of pain and discomfort. If the court is not inclined to release him on his own recognizance.
Well, he has a felony capias that was just issued.
Is this a capias?
Yes.
Oh, I see, okay.
In front of Judge Scher.
Then, Judge, I'd ask you to order a medical screen for Mr. Edwards to make sure that he's getting the proper medical attention he requires
Draft
while
the
in
order,
jail.
I'll sign it.
I will draft it.
Thank you. Okay, bond will be at $1,000. Thank you, sir, and have a good day. Hope you feel better. Are we back with Mr. Chamera?
Mr. Chamera's here present, Judge Amin?
Yes, sir.
Okay, you've been charged with possession of a weapon or ammo by a convicted felon, possession with intent to sell cocaine, possession of cannabis. Count 4 is DUI with property damage. Count 5 is DUI property damage. 6 is DUI property damage. 7, DUI property damage. Count 8, DUI property damage. Count 9, DUI alcohol or drugs. Count 10, disobeying or avoiding a red light. And count 11, no insurance.
Pick up, magistrate.
I do find probable cause. And State, do you have a recommendation or priors?
Well, as far as priors to advise the court, 2013, sale, delivery of cannabis within 1,000 feet of a place of worship. Your Honor, I'd be requesting $2,500 bond on one, and just ask that the convenience bonds on the rest of the charges be kept in place.
Judge, in speaking with Mr. Chamera, he's been residing in South Florida his whole life. He is 25 years old. He is currently employed. He works at IHOP. He's been working at the same IHOP location for 1 year now, making approximately $10 an hour. He lives with his grandmother. They reside in Coral Springs. He's been residing at the same apartment for the past 7 years. What we'd be asking you to consider is setting a bond on count 1 of $1,000, and on the DUI with property damage, I noticed that that's on count 4, 5, 6, 7, and 8. We'd be respectfully asking you to consider an ROR on counts 5, 6, 7, and 8, Judge.
Okay, do you have any objection to that?
No, Your Honor, I would just be asking the court to set the bonds that were recommended. He has a prior for essentially the same type of allegation with a different substance, in possession of a firearm, and it appears that there were obviously multiple vehicles involved in this accident.
Okay, what I will do is I'll set the possession, count 1, of a weapon or ammo. I'll set it at $2,000. Count 2 will be $7,500. Count 3 will be $100. Count 4 will be $1,000. Count 5, I'll make ROR. Count 6, ROR. Count 7, ROR. And count 8, ROR. Count 9, 500. And then ROR count 10 and 11.
Thank you, Judge. And also a photo order. I forgot to request that.
We will do a photo order. If I see the order, I will sign it.
Thank you, Judge.
Christopher Terrell Thompson.
North Broward.
Okay, sir, you were charged with a petty theft, possession of cocaine, possession of cannabis. You have a capias, count case 17227 MM 30A, and a capias 17227 MM 30A. There's 2 of them, each 250. And then a violation of probation for 15011 539 MM. Let me see, the print gets smaller every time. 10A with a no bond hold, and that will be heard on May 22nd, 2017 at 2 p.m. State, do you have any recommendation on the other counts?
Your Honor, I'm going to be asking that count 1 be set at $1,500. He's on probation for theft. He's got a pending theft that he didn't show up to court on. I'm getting hits for priors out of Georgia, Michigan, Texas, and Oklahoma. I'm showing an open warrant out of Dade County right now for indecent exposure, failure to appear in court.
Is it urinating?
Okay. So.
Okay, Mr. Reedy?
This is on Mr. Thompson, Judge?
Yes.
Well, in light of the fact that he has a no bond hold, Judge, I think that he needs to go in front of his regular judge anyway. So I'd ask the court just keep the bonds where they are.
And if his probation judge was the same judge, I'd be seeing him on count 1, I'd agree. But it's not. The probation's a misdemeanor. He'll be seeing an entirely different judge on count 1.
Okay, I'll set bond on count 1. Set it at $1,000. Count 2, $1,000. Count 3, $100. Count 4, $250. Count 5, $250, and a no bond hold on the violation of probation. Thank you, and good luck to you, sir.
Thank you, sir.
Jeremitris DeVoe.
Mr. DeVoe, come on up, please. Mr. DeVoe, here, President Main Judge.
Okay, Mr. DeVoe, you're here on a violation of felony probation, case 12-17336 CF10A. The hearing is set for May 17th, 2017, 8:45 a.m. And so you're on a no bond hold until then. Okay, good luck to you, sir. Ryan Kirby.
Mr. Kirby?
You are charged with possession of Xanax and possession of cannabis. State any priors.
He's got 2014 burglary of a conveyance, obstructing fire equipment, and resisting without violence. Just asking that the $1,000 convenience bond be kept in place.
Counsel?
Judge, and speaking Mr. Kirby, we respectfully be asking you to consider pretrial release. He is currently employed. He works for Right Choice Pools, for a pool company. Judge, he lives in Fort Lauderdale. He lives with his girlfriend. They've been, grandfather, I apologize, grandfather. He's been residing at the same location for 2 years, so he does have a valid address. If pretrial can verify, we'd be asking you to consider releasing Mr. Kirby on standard pretrial, considering this is a non-violent offense.
State any objection to pretrial release?
If they want him, I don't know if they verified his address.
Pretrial, do you have an address?
We were unable to make contact with his family to verify the address.
Okay, what would you like to do?
We didn't hear what
They
pretrial
have
said,
not
Judge.
been able to contact his family and
Well,
verify an address.
What would happen, Judge, if you do release him on standard pretrial, he'd be released. He would report to pretrial
by today, or if it's too late, tomorrow by 8 in the morning. And then at that time, he would give him the information as far as where he lives and everything like that.
You can also order him to pretrial pending verification, where he can either post a bond, or if they verify an address, he'll be ROR to pretrial.
Okay, I will do pretrial, ROR, pretrial pending release, pending address.
Well, Your Honor, it's $1,000 bond pending pretrial. Because if you ROR, they just have to release him.
Well, I don't want him to have to pay a bond if he goes to pretrial.
No, he won't. If they verify his address, then they will release him to pretrial.
Okay, that's what I'll do. $1,000, no ROR on count 2. He'll have no bond to pay. He'll be ROR'd if he gets into pretrial.
You just have to do pending verification.
Okay.
Thank you, Judge.
Thank you. Wilson Profet.
Mr. Prophet?
Okay, you've been charged with possession of cannabis. Standard bond's $1,000. Counsel?
Yes, Judge. If the state can verify, my understanding is this is his first felony offense. He's been residing in South Florida now for 6 years. He's 20 years old. He graduated from high school, from Flagler High School class of 2016. He is currently employed. He works at the Quick Stop. He's been working there for 2 years, making about $10 an hour. At this time, he is saving up money to attend Broward College. He plans on studying to be a computer technician. He lives in North Lauderdale. He lives with his sister. He's been residing at the same location for 2 years. Judge, considering his strong ties to the community, his lack of any sort of criminal priors, Judge, we'd be asking you to consider an ROR, considering this is his first offense and it's a non-violent offense, Judge.
State?
He has no criminal history, Judge.
Okay, I'll ROR him.
Thank you very much, Judge. Appreciate it.
Evangelist Demps.
Mr. Demps, come on up, please.
Okay, he has a parole violation with a no bond hold and a possession of cocaine, the standard bond at $1,000. I do find probable cause. Do you have any objection to a $1,000 bond?
We'd be fine with the convenience bond, Judge.
I will set bond at $1,000.
Thank you, Judge.
Okay, Quest Malik variance.
Mr. Variance, come on up, please.
Okay, he's been charged with resisting without violence, violation of probation felony with a $5,000, and then a third count probation violation with a no bond hold. His violation of probation will be heard May 17th, 8:30 a.m. Any objection to the standard bond?
None from the state.
No objection.
I'll set bond at $100 on count 1, $5,000 count 2, and a no bond hold on the violation of probation. Thank you. Anthony Cara, C-A-I-R-A.
Mr. Chiara, come on up, please.
Okay, he's charged with grand theft auto, convenience bond of $1,000, fleeing and eluding, resisting without violence, standard is 100. Then he has a warrant violation of pretrial felony, case 17-00, 572 CF 10A with a no bond hold, and 17-00887 CF 10A with a no bond hold.
Okay, Judge, I've been advised Mr. Chiara has private counsel, Mr. Michael Weinstein.
Okay. Do you want me to reset this for the afternoon, or I'll set the standard bond at $1,000 for count 1? Count 2 will be $100.
Your Honor, the state would object to $100. It's a second-degree felony. I'll wait till Mr. Kyra states if he wants to have it reset or not. I think the court should be aware of his criminal history also.
Okay, tell me your
What's the second degree felony?
What are the priors?
He's got 3 prior burglaries, 2 prior grand theft auto, a prior grand theft. He's been to prison. In 2014, he went to prison, was classified as a habitual offender for identity theft and petty theft.
Is that it?
Yes.
Okay. Mr. Kara, would you like your attorney?
I want to know what's going on.
Well, I'm not going to talk to you until you answer
I don't
my
know the
first
charges.
question. Would you
I
like
wanna know
your
the second.
Would you like your
No.
attorney?
No.
You are charged with grand theft auto. You are charged with fleeing and eluding a law enforcement officer at high speed. You are charged with resisting an officer without violence. You have a no bond warrant for a violation of pretrial felony on case 17-000-572 CF-10A and a warrant for violation of pretrial felony 17-000
That's 2 of them.
887 CF-10A. Would you like me to have you called back in the afternoon? I'll call your attorney and you could have him to talk to?
No. No, I'll talk to him. No. That's fine.
Okay, so what's the recommendation on the bond?
Your Honor, state's recommendation on count 2 would be $3,500.
Okay. Based on your priors, I consider you to be a danger to the community. I'll set your bond at $1,000 on count 1, $3,500 on count 2. Count 3 will be 100, and you have a no bond hold on counts 4 and 5. Good luck to you, sir. Brandon Lee Rogers.
Mr. Rogers here present, Judge?
Okay. You've been charged with possession of heroin and resisting without violence. I find probable cause. State, do you have...
I'm just going to ask that the convenience bond be kept in place. Mr. Rogers was arrested February 1st of this year for, looks like, theft, bat leo, possession of cocaine. He was ROR'd on all the counts. For the state not filing an information has still not yet been filed. He had a resisting without violence and unlawful use of false name ID in 2016 and a trespass in 2015. That was under the name Harry Rogers.
And what's your recommendation, count 2?
Your Honor, I'm just fine with leaving that as no charge.
Okay. State, counsel.
Defense is no objection to that, Judge.
Okay, I'll set bond at $1,000 and count 2 will be an ROR. Okay, Andrew Casa.
Mr. Calta is present.
Okay, sir. You've been charged with grand theft, resisting officer with violence, resisting officer without violence, grand theft, and a petty theft. And the grand theft count 4 is 17-04835 CF10A, and the petty theft is 17-05190 CF10A. Anybody have anything to offer?
Your Honor, I'm going to be asking that counts 1 and 4 be raised to $2,500 each. 2015 felony theft, 2012 grand theft. He violated probation, was sentenced to 24 months state prison. Actually, he violated probation on the 2015 felony theft as well. 2011 strong arm robbery, VOP, 24 months state prison. 2008 trafficking in oxycodone and conspiracy to traffic oxycodone. And 06 he had a breakdown of a DUI to a reckless driving.
I have a problem probable cause-wise with count 2, Judge. I don't know that this is resisting arrest with violence. It looks like he struggled, pulled away. I don't see any punches being thrown, any kicks, anything like that in the probable cause affidavit.
Your Honor, oops. There were punches and kicks beat that Leo.
Okay, actually, I agree with the
Well,
council.
Your Honor, you don't have to throw a punch or a kick to do resisting with violence.
Okay,
If
he
you-
didn't, I'm gonna allow you to perfect on count 2 if you'd like to. I see nothing showing any violence. He tensed up. The officer swept his leg. He tried to get up a couple times, and he ran. They grabbed his arm. It didn't look like he did anything. If you'd like to, I'll give you 24 hours to perfect.
Okay.
And I'll be here tomorrow, so
I know.
you can do that. What are the anything else, council? Because they requested a higher bond based on priors.
I have nothing further. Maybe Mr. Romero can provide some ties to the community.
I do, Judge. In speaking Mr. Causa, he's been residing in South Florida his whole life. He's 29 years old. He's currently employed for a company called RSI Roofing. He's been working for them for about 5 years, making about $14 an hour. Financially, though, he's very limited. He lives in Oakland Park. He lives with his girlfriend. They've been staying at the same apartment now for about 3 years. His monthly rent is about $1,200, so right now his bank account is practically at zero. It all went towards paying the rent. I'd ask you, Judge, to consider leaving the standard bond in place on count 1, count 3, and count 4 and 5. I'd ask you to consider at this time on count 2. I know the state has a right to ask Your Honor to for 24 hours to perfect. I'd ask you at this time to set it as $100. So that way, Mr. Causa will be financially or will be potentially be able to bond out, as opposed to not leaving it as is. That would effectively be holding Mr. Causa no bond until tomorrow. So therefore, the defense would be asking for $1,000, $100, $1,000, and $750 for count 5, Judge.
Do you have any objection to count 2 being $100?
That's fine, Your Honor. The only thing I would note is just reviewing the reports. It appears that Mr. Causa is targeting the same business. Both thefts he's been arrested for were against Publix.
Well, I will set bond at count 1, $2,500. Count 2, $100. Count 3, $100. Count 4, $2,500. Count 3, $750. Okay. Good luck to you, sir.
Judge, for the record, is the state requesting 24 hours to perfect? Okay.
Yeah, there. Okay. You'll be brought back over tomorrow.
Jesse Rather.
That's North Broward, Your Honor. That's a medical reset.
Thank you.
You're welcome.
Passing along. It's been here all weekend.
I don't see anything else on the docket. Is there anything I need to be aware of?
I know.
Counsel?
I think that's it, Judge.
Okay, we'll be in recess till 1:30.